In this episode, Swee and Co and Duncan Watsons join us to talk about the craft behind persuasive advocacy and the small choices that makes a big difference. They explore how clarity comes from simplicity and structure, how storytelling can sharpen an argument, and why a well-timed pause can speak as loudly as words.
So Duncan, it's been quite some time since you've been here in Singapore, and here we are doing this podcast together. I'm pretty excited about it. Is this your first time?
It absolutely is, and I feel like I'm in very safe hands with you, Swee, so thank you.
Not that safe hands. I'm sure there are many others who've done multiple podcasts. This is just my second after my first that I did together with Maxwell Chambers. Well, we are here today to talk about the power of word choice, and I thought perhaps I'll start off by asking you, how important do you think style is to effective advocacy?
I think, well, first of all, thank you to Maxwell and thank you to you for being here with this. It's an exciting thing to be part of, and it's something that I think about a lot because it's such an important part of our job as advocates and as lawyers in disputes. And I think style is really important. Obviously, that's why we're here. And it's partly because dispute resolution advocacy is still, for now, a human job. It's a human process. And when we talk about advocacy, what we're really talking about is trying to persuade another human being that you're right about whatever it is your case is about. And so you're trying to persuade another human being. And so you need to try to connect with them on a human level as another human being. And you do that through, I think, what we would call style. And I think there's a sort of performative aspect to that. You know, it's not just a conversation with a colleague or a conversation with family. It's a very particular kind of connection. And it's part of it is the performance that you're doing as an advocate, which is the style that you're talking about. What about you?
Well, I really like the word that you just said, which is connection. Because for me, I've always found that the most important thing when it comes to advocacy is to connect with the tribunal members. And I've always said this to my juniors when they were, training, and sometimes they come up a case, a much more senior opponent, and they get really nervous. And I always tell them, you know what? Don't worry about the opponent. The key thing is to communicate and to connect with the tribunal.
Yes.
And to be able to do that, you must find a distinctive way of being able to connect. Different people connect by different ways. I think some people, they do it. Some people have excellent eye contact, and that's very, very basic. But it's also about the tone. It's also about the pauses. It's also about, just listening and maintaining that relationship with the tribunal members. So I agree with you. I think connection is extremely critical. And when I look at oral advocacy and then at the same time written advocacy is so important in our international arbitration work, I often say to the team, you may have great substance in your written submissions, but if it is badly formatted, badly structured, and you're not able to look at the points and to understand the way in which they interact with each other, then you lose all the sort of strength of the substance of your submissions. And when I look at oral advocacy, I feel that that's somewhat the same, because if you have all the substance, you have the facts, you have the law, you have the logic, you have the fairness, the justice in your favor, in your client's favor, but you're unable to deliver it and make people understand, then you lose everything. So
absolutely, I completely agree. And I think just sitting there or standing there, whatever your forum, and reading from a script is so ineffective, because if you're looking down all the time and just reading words on a page, then you can't make that connection.
Yeah.
I don't think there's anything wrong with having a script if that's how you prepare, but to be stuck to it and to be reading it out as though you're delivering a lecture or something is completely the wrong exercise.
Yeah, so you talk about script, and I think both of us, we came here today with like papers in our hands and, not a laptop. And one thing I've started to notice in a lot of oral openings in international arbitrations is that people stop using a script and they start to have this laptop in front of them. And I don't know what you feel about that, but I always feel that having that laptop screen there creates a barrier with the tribunal members, is even though your eye level is above it, but there's a barrier. So I don't know what you feel about
No,
that.
I agree. And I think that the use of technology, has increased so much. And you have the laptop for the transcript, and you have the laptop or the big screen for the evidence. I always try to move them out of the way so that I can face the tribunal without any barrier, any obstacle.
Yeah, because when I sit as a tribunal member and I have advocates who have that barrier, then I feel that there's a certain breakage in their communication with me. So which is why I generally don't use laptops when I do oral advocacy, but it made me feel even more conscious about that. And one thing I wanted to also ask, is what do you think is sort of an effective style of advocacy? And what is your personal style like? How would you describe yourself?
That's a hard question, because I think it forces you to think about yourself in a way that, or myself in a way that I'm not used to doing. But I think what I try to do is be simple. I don't, I'm not, occasionally I'll go off on a rhetorical flourish maybe, but I'll try to keep it as simple and as straightforward and as plain spoken as possible. That's just my style. It wouldn't work for some people, it would work for others. But I think simplicity is really important when you're trying to persuade someone in such a complicated area as the ones that we practice in. And in fact, it was about 10 years ago when I first moved to Hong Kong. So Bernard Ricks was there. He was sitting on a tribunal and then did a fireside chat type seminar at the HKSC. And he said something that has always stuck with me, which is that the three principles for him, I think it was judgment writing. We were talking about his time as a judge, but I think it applies all across the law, is that there are three principles: analysis, refinement, and simplicity. And they sort of go round in a circle or a triangle. But you've got to do the analysis, obviously. You've got to do all of that research and reading of the papers and thinking about the evidence and all of that. You've got to refine that as deeply as you can, and then you need to simplify it. The end result is simplicity. And I thought that was a really insightful way of putting the exercise of doing what we do as disputes lawyers. And it's something that I've really tried to internalize.
Yeah.
What about you? Tell me your personal style.
I couldn't agree more. And it's really interesting that we seem to share so many sort of parallels and similarities, despite the fact that we have such different legal training and coming from different jurisdictions. But that's also my style of advocacy, simplicity. So what I tend to do is I would always drill and make the most complex things in the most simplistic way.
Yes.
So even when it comes to what I found in oral opening that I spend quite a lot of time on is on expert evidence.
Yes.
So while I have an expert who may be coming up and who may be doing the presentation, but I really try to explain the expert evidence in the course of my oral submissions and to try to make it as simple as possible, even if it's a very complex exercise. And you're right, or what you said about Justice Ricks and what his advice is. First, I've got to analyze. I've got to fully understand and appreciate the expert report before I could break it down and make it simple. And often I find that people who tend not to simplify matters and they tend to make it very complicated, don't really quite know and understand the case theory, which is why they are unable to break it down to simple terms. And I was taught to make things simple. I was taught also by Alvin Yeo, who was my senior partner, who has since left us. And he always said to me, make your submission simple and go for the best point. Yeah. If you can't persuade the tribunal of your best point, then why bother with the rest of the points? So that's sort of a philosophy that I live with. And, talking about my mentor, I wonder whether you have any sort of, has your style evolved over the years? Has your style evolved based on the persons that you've worked with or interacted with or seen? Because every day I'm learning. I mean, for me, that's the beauty of advocacy. You're always trying to be better. The more you do.
Yeah. Yeah, and I think, I'm sure it has. I'm sure my approach and my style has evolved. I try to watch what other people are doing and think, that works really well for them, it wouldn't work well for me, or that would work well for me, I can try to adapt that to my own way of doing things. I've had a couple of important mentors over the years. Supervisor KC now has left my firm, but she was the managing partner of our London office when I first joined our London office. And she helped me sort of find my own voice and my own way in what we do. And I think finding your own voice is a really critical part of it, because as I said before, when I watch what other people are doing, it might be really effective for them, but I know it won't work for me because of my own personality or my own voice or my own, approach to things. I just know it won't work for me. And similarly, as I said, I try to be plain spoken. I think for other people, that probably wouldn't work. They have a more rhetorical personality, or they have more flourishes about them. And if they were to try to simplify it too much, it would come off as inauthentic or insincere. And I think, although we seem to now be very similar, I think it's so important to find your own personal way of doing it. And that authenticity, I think, is how to build the connection that we were both talking about earlier, because it's about persuasion. And if you're coming across as someone who doesn't believe in what they're saying, or has put up some artifice between yourself and the person you're trying to persuade, then your message isn't going to get through. So I think that's something that I talk to my team about. Don't just copy me.
You sound,
because that won't work.
You sound like me.
Right. Find your own way of doing it. And what I do works for me. I know that because I've been doing it for however long, but it won't necessarily work for you.
Yeah. I mean, it's when I started practice, I did a lot of mooting before I, started and came into practice. And from my own personal style in the past, I was very much more aggressive.
Right.
Yeah, because I started off with court litigation.
Right.
So in the court setting, there's a certain type of style, or a certain advocacy style which works better because of the whole setting in which it is. It's also the judges and which particular judge you are before. And having then worked and observed many, including my mentor, Alvin Yeo, having observed Andre Maniam, who is my other mentor in the firm, who's now in the Supreme Court judge. And I've really learned how to sort of be and adopt a much more reasonable style or a reasonable approach to, my arguments. So in the old days, I would always go for the most extreme arguments, like really set my case too high, way too high, and not necessary to be able to win the case. And through the years, what I've learned is, you don't have to set your case or set the bar so high for yourself to be able to win the case. You should always think what is sufficient for you to win the case and go for that. Because, that reasonableness that comes across, it makes a huge difference. And particularly depending on who the tribunal members or who the judge is. So I really adapt depending on who's the tribunal members or who's the judge. And I still do court litigation now. So I still do my court litigation. We go before the SICC, the Court of Appeal, the High Court, and then before tribunal members. And I must say that I'm quite a different advocate depending on whether it is before a particular High Court judge or whether is it before tribunal member. So I'm just wondering for yourself, you focus on international arbitration. Do you also likewise adapt when you have a different tribunal members, and how does that influence your advocacy?
Yeah, I do. It's a really good question, and I'd like to come back to your point about court and arbitration in a moment. But I do, and sometimes it's just subconscious or unconscious, because it's about connecting again to the one or the three individuals sitting before you, and that might be a retired English judge, or it might be a Korean law professor, or a Chinese practitioner, or whatever it is. And each of those people will be bringing their own legal culture, their own language, their own personal culture to that hearing room. And you need to find a way to connect to each of those people in a way that will work for them. And I would say that the fundamental sort of foundation is the same, because I am who I am, and I can't change that. But the way that the phrases that I use, or the language that I use, or the length of sentence that I use will just sometimes quite naturally change. And I think the same is true with witnesses. If I'm cross-examining a witness through interpretation, that's a very different exercise from cross-examining a witness fluently in English. For one thing, just pragmatically, you have to keep your questions much shorter, much tighter, much more focused, so that then the translator or the interpreter can keep up with you and keep the point. And you also have to have your overall plan much tighter, because things take so much longer. I think I've answered 3 or 4 questions rather than just the one you asked me. But I want to come back to this idea of court and arbitration, because you said one difference was aggression, the level of aggression that you bring to court or tribunals. Are there other differences?
Well, when it comes to cross-examination of the witnesses, again, it's the whole setting in the courtroom. So when a witness is sitting there and the witness is under oath, under affirmation, she feels a particular compulsion. And in the courtroom, you would have let's say if the witness is not answering you directly, you tend to confront the witness much earlier than, say, for instance, in arbitration, where the arbitrators tend to take this view that the witnesses are really here to assist in the case. They're really not, they don't have to be here. And so because of that, you need to treat the witnesses really very gently, very, not just, you should always be kind to the witness. You should always respect the witness.
Yes.
But it's a much more gentler approach to witness testimony as compared to in the courtroom. So for instance, in the courtroom, we may, when it comes to cross-examination, even put to the witness or even suggest to the witness that, Mr. Tan, that is a lie.
Right.
Okay. And I almost have not used this phrase in arbitration.
Yeah.
In fact, how I would say it is, Mr. Tan, you're not being candid. Or Mr. Tan, you have omitted this. So it's sort of different, but in the courtroom, I would actually use that word at the right situation, of course, when it is a clear lie. Yeah.
That's interesting. And I think in arbitration, you have to think about the legal background of your tribunal as well. And the reason I say that is because of a story that has been triggered by that example you gave. In a case that I had quite a few years ago with a mixed tribunal, English, Austrian, and American opponents and an American witness seated in London. And I asked a question. I asked a question along those lines. I said, "You're lying about that, aren't you?" Or something. And the whole room blew up. And it was the weirdest thing. Everybody sort of got very angry and vocal, and my opponents, that's completely improper, that's completely unacceptable. And I said, well, I'm just doing this because, my legal training is that you have to put to a witness when subsequently you're going to invite the tribunal to find that they were lying or that they weren't untruthful. If we're not going to follow that principle here in this case, I won't ask those questions. But it was, for me, a really interesting example. We were all native English speakers. We were all common law trained. But because of my particular English Australian background,
yes, very similar to Singapore.
Very similar,
background.
exactly.
Yes.
I asked a question that was aggressive in the sense that I had to put to him that he was lying, but it was a very ordinary question in the sort of background that I'm from. And it drew this enormous and unexpected reaction, unexpected on my part. And it was just because I hadn't taken into account that difference in the legal background of my opponents in particular. And the tribunal, very experienced international tribunal, had to explain to the witness and to my opponents what I was doing and why, and that it wasn't improper in any sense. I was just doing it because of this particular rule that we could dispense with and therefore I
like
didn't
the
have
Brown
to.
and Dunn sort of principle.
Exactly.
Yes. So, which is why now I think in most arbitrations, some tribunal members, they do make it a point to say that, well, we are agreed that the Brown and Dunn
Yes.
principle will not apply, and then,
Yeah.
the arbitration proceeds in a particular way. Talking about the traditions of arbitrators, I also find that extremely important because I had this one experience where I had to appear before 3 civil law arbitrators, and they come from particular jurisdictions where the lawyers do not even make submissions in court. They tend to just submit, say, a list of evidence, and then the judges will just decide the matter. That is the judicial system which they came from. So I always find that oral openings are extremely important. And, bring the tribunal through the key documents, the key contract terms, as well as the documents you wish to rely on is important because the tribunal will then read the document in the way that you hope and you wish to persuade them to do. At the start, when I raised the oral opening, and I said I wanted, say, 2 hours to do the oral opening for a case which is rather complex, they were initially extremely resistant to it because they were not into this, oral submissions. Their point is, let's just have everything decided on paper. But I thought it was extremely important to insist on the oral opening. And I have to say, I insisted politely. I explained how it was very important to our case. I explained that there were certain key documents which we wanted to show the tribunal. And also I said I will stay within my allocated time. I'm not going to exceed it. If I spend more on this, I'll spend less time on cross-examination. And I then also asked and factored in an oral closing, which I thought was very, very critical in closing off this particular, drawing together the witness evidence while it was fresh in the tribunal's mind.
Yeah.
And I think that really influenced the final outcome. It is one of those cases which, if not for the fact that the tribunal in the end decided to allow us to do the oral opening as well as the oral closing, it might very well have been a different outcome. And I just wanted to see whether you personally have any experience to share on this. And if you face arbitrators who are not prepared to give you a sufficient length of time for your opening, closing, then how do you deal with that situation?
I agree that oral openings are very important because although you like to think that arbitrators will come to a case prepared, and often they will, it's still a really powerful opportunity for you to tell your story up front without interruptions. Although you may get some questions. It's much easier to tell your story from start to finish through submissions than through cross-examination where each witness might have a piece of the story and you can only deal with it in bits and pieces. So I think that is absolutely right, absolutely important. Oral closings, I'm a bit less persuaded by the need for. I can see how sometimes it can be really punchy and really powerful. And I had a case in 2022 in Singapore, actually, before I moved here, where it was a very short hearing. It was 5 days. There was a lot of evidence. And on the Friday, we didn't have any gap. We didn't have any time to prepare, but I just gave a 20-minute summary of the evidence that went point by point, and drawing it all together in just a very short period of time I felt was really powerful. And as you said before, doing it while it's fresh.
Yes.
After they've just heard it, but something happened on Friday, and then drawing the link to what happened on Thursday and pulling it all together can really land the right impression that you want to make.
Yeah. And this phrase that you use, storytelling, I think that's also something that I always remind myself. And also when I speak to my team, and I always say, why should we win?
Yeah.
What is the narrative here? What is the story that we need the tribunal to feel for our client?
Yeah.
How are we going to persuade them to empathize with our clients, to feel that our clients are the ones who should win? And sometimes you may have a more difficult case on the law. Sometimes you have a more difficult case on the facts. I mean, if you have a very strong case, you probably wouldn't be in arbitration. You would have settled the case. That's what I tell most of my team members. So if you're already there in arbitration, what is that narrative that you want to present? And one of the tips that I always tell myself is, I say, I want the tribunal to walk away remembering something from the case.
Right.
And I tend to use this technique of a few sort of catchphrases that I want them to walk away thinking of it. So for instance, when I was trying to set aside a contract for mistake, which is challenging, so I wanted the tribunal to have this sense that this was based on a scheme that the other party had concocted.
Right.
You know, if I wanted to say that the other party had changed its, its position, I may say afterthought. I may say that they're trying to take advantage of the client. They're trying to, get out of a bad bargain. Things that make them remember the case. And so I just
in the right way.
Yes, in the right way. So I wanted to ask you, in the sense of narrative storytelling, how do you use that in the advocacy?
I think that's a really important topic, and it's one that we talk about a lot. I think when we're talking to our teams, to each other in professional contexts, what's the narrative? What's the story? And I think there are a couple of elements to that. One is, as you were saying, you want the tribunal to come away feeling like your client should win.
Yes.
And to some extent, that's a sympathy or an empathy or an understanding point. You want the tribunal to feel like your client is the party that's been wronged.
Yes.
But I think it's also just, it's simpler than that, in the sense that, it comes back to the point that I started with, that we're in the business of persuasion and trying to persuade someone that you're right. Sympathy will only get you so far.
Yes, if the law is not with you.
Exactly. Because the law is rightly a technical area. There are rules, there are cases. That's the framework in which we're operating. Sympathy won't win you the case. It'll help, but it won't win you the case. And so I think when we talk about narrative, we're talking about the whys. Why did this witness do that? Why does the law have this effect in this context? And the connections between each part of the case. What led this to happen from that to that to that? And it can be factual. That's a very clear example of storytelling. You want to explain to the tribunal what happened. But it's also about the law and the legal analysis, and the whys and the connections between your propositions or your arguments are so important. I'll never forget the feeling that I had in arguing a closing submission in a case in Taipei years ago. It was a case about a fraud, and so we had the factual side of the story very clear, but there were very technical legal arguments involving Singapore law, Taiwan law, Hong Kong law. I remember in closing trying to explain these intricacies and just making eye contact with the chair arbitrator, explaining, stepping her through the analysis. And I felt the feeling that I had was that I was telling the most boring bedtime story in the world, but it was still a bedtime story. Just the way that I was making eye contact with her and stepping through and explaining this leads to that, leads to that, leads to that, leads to us winning. And I think that part of the storytelling or narrative idea is really important. Yeah. What about you? What do you mean by storytelling or narrative?
Well, right, it's almost, I'm starting to sound like a broken record, but I'm going to say the points that you make, I entirely agree with. Because it's the same way. I'm a very structured sort of speaker. So when I do my oral opening, when I do my oral closing, you try to put together all the evidence. When it comes to opening, I like to deal with things in a chronological way, because it always tells the story and it explains why certain things happen. What is it that caused this turning point in the relationship? What then happened thereafter? So to me, drawing together all the different strands and putting, when I'm telling the story, that's when the law also comes into play.
Yes.
So it's all within together. It will not be, these are the legal principles, and then applying these legal principles, this is what happens. I mean, that's not the way I would do oral advocacy. It is always the story, and the law and the provisions of the contract and the letters will all be weaved into the story to present something that I feel is persuasive. And that I think is very important. And I always feel very excited whenever I do my oral opening, because that to me is, I spend time, I don't have a habit of writing down every single word which I'm going to say in my oral opening. That's not my style. But what I tend to do is to just write down the document references. So the key document and the key points that I wish to bring the tribunal to. And then I will then from that, using that, tell the story. And in the midst of telling that story, ask the tribunal to refer to those provisions, to refer to those documents. So that's something which almost in all my openings I do. It's sort of try and tested and something which I found really effective, because the tribunal starts to get interested. Like even in that earlier case that I was mentioning to you, while they're very reluctant, and a lot of times when I raise this point of having at least a 2 hours opening, they tend to be very reluctant about it. But after you start to bring them through the documents and you start to tell your story, they start being interested and they start asking questions. And I love questions from the tribunal members, because that's the only way I could get a sense of what's troubling them. And that's one aspect. Again, in advocacy, I think reading the tribunal, constantly being alert and alive to how he or she is reacting or responding to what you're saying is so important, because the worst is if he or she is not following. And then that's when you really need to, get their attention. And sometimes that's when I'll ask them to please turn to, page 28, which is a very important document. And then suddenly everyone is alert again.
Right. I think, and that's another reason why reading from a script is so ineffective, because you can't see how they're reacting to what you're saying. One thing that you said before, I think, is really important, just structure. And it's something that I talk a lot about with my team. And I think structure is, in a sense, the key to written submissions, to oral submissions, for a couple of reasons. One, having an overall logical flow helps you with the narrative, the whys and the connections. It helps build up the story in a way that the tribunal will understand. But also when you break it down, I mean structure within each point as well. So something that I'll do, you were saying something similar a moment ago, is when you talk through the contract, I'll pause and say, well, this is what this clause means, this is why it's here, this is what it does. And there are 3 points that I want you to take away from this. 1, 2, 3. And then keep going.
Yes.
So in the interleaving that you were talking about, I think that's a much more effective way of trying to persuade someone and bring them along, and even just to make them understand what your case is, rather than saving all of the legal points to the end.
Yes.
And I think it's also, that's what I say to my team, it's a shortcut to building credibility.
Yes.
Because it shows that you've thought it through and you've tried to break it down. And that, I think, puts you ahead of a lot of people already from the start. If you've shown that you've thought through your case or the point that you're making or your application or whatever it is, and you've broken it down into points to help the tribunal follow, then they'll already sort of automatically feel, oh, okay, I can trust this person to help me understand things. And I think a shortcut to credibility is absolutely something that we should all take.
Yes. And again, I'm going to say I agree with what you've just stated. And, we talk about word choices and using the words. And I think both of us agree that the choice of words is extremely important. I'm very precise in my language. When I read a contract, when I read a clause, I read the precise words that's in the contract. I never paraphrase.
Yeah.
It irritates me very much when people are not precise, when people do not use the same words.
Yeah.
When each and every time they talk about a particular breach, they change the way they speak about it. It irritates me. And so I'm very, precise with each and every word, phrase, turn of phrase that I use. But at the same time, I've also found something which is very powerful, which is when you say nothing at all. So an effective pause in the oral submissions, or even an effective pause in cross-examination. Particularly, I recall once when I was in the midst of cross-examining this particular individual who was supposed to have given all the evidence on the substantive defects in the project. So all the defects is sort of a bit construction related, infrastructure related. And I had prepared this entire list of cross-examination questions for him. And he was obviously subordinate to someone who's his superior. So the first question I had asked him was simply, so you are subordinate to this Mr. A? And he was like, yes, I'm his subordinate. So I said, do you generally take instructions of Mr. A? He says, yes, I take instructions of Mr. A. I then went on to say, so Mr. A was the one who asked you to testify? And he said, yes, Mr. A is. And I said, so this witness statement you prepared, did you prepare this on the instructions of Mr. A? And then he said, yes. So I said, whatever Mr. A asked you to sign, you would simply sign. And he said, yes. And then I said, so the contents of this witness statement, is this something which Mr. A asked you to sign? And then he said, yes. So I said, and regardless of your personal knowledge, you would just simply sign this because Mr. A asked you to do so? And he said, yes. And then I just paused. And after I paused, I was very concerned because I didn't want to be so hasty to just simply say, you know what, I've got it.
Yeah.
I wanted to have a chance to read the life notes again, to sort of have this sink in to the tribunal's mind. So at that moment, I then asked the tribunal for a break. I said, I would like to take a break so that I could take a look at the transcripts and see whether I needed to continue further. So there was a break. So when I then came back and I said no further questions, that was powerful. So
absolutely.
So I would say sometimes, the pause of saying nothing is quite a powerful in advocacy.
Yeah, absolutely. I think even when you're cross-examining an expert, if you ask a question that you're sounding reasonable, want their help, and they just don't know the answer, or they can't. You can see the cogs turning. How do I answer this in a way that doesn't destroy my credibility or that supports my case, whatever? Just sitting back and waiting for it.
Yes,
can be so effective, even though it can feel like you need to fill that gap. You need to ask a follow-up question, or you need to ask if they want the question repeated. Just sitting back and letting it sink in, as you say, can be so effective.
Yeah. So, this has been really great fun for me. And I wanted to see whether you had any last, sort of tips that you would share with, upcoming advocates.
I think the most important thing that I can say is to do it your way, to find your own way of doing it, and to watch and listen and learn from other people, but don't copy them.
Yes. And
don't think that there's only one way of doing it, to find your own way, because being an authentic advocate is always going to make you a more effective one than, compared to fluency or rhetorical flourishes or whatever else it might be. Authenticity is really important, but you've got to have the foundation of preparation.
Oh, yes.
You've got to have the sense of mastery of the case, of the record, of the facts, of the law, whatever it is, because without that, you won't have the confidence of the tribunal, or the court. You won't be able to persuade them of anything if they don't think that you know what you're talking about. What about you? Your final reflections, your
my final
tips.
Reflection. I think practice. So practice makes perfect. The more you do it, the better you become at it.
Yeah.
So I think as a young advocate, every single opportunity that you have, you should, practice. Practice, think about your case, make it better, reflect on it the night before, the days before the actual performance.
Yeah.
And as a senior like you, I try to create as many opportunities as I can for my juniors, because I know practice is the best way for them to improve. So I think that's something which both of us would do to ensure that there's this platform for them to keep practicing.
I think that's really important. And I think also that tribunals, I can't speak for courts, but I imagine that it's quite similar. They want to see the younger advocates come up, and they'll give you more leeway. Yes. I think they'll give you more of a a cushion. They'll be more encouraging. They'll
Yes.
ask you questions. They won't necessarily go easy on you, but they will be so glad, I think, to see you having a go.
Yes.
That you shouldn't be afraid. You should be nervous because that will drive your preparation and so on. But know that you'll have a welcome audience.
Yeah. That's great. So, well, I look forward to the next podcast with you, Duncan. It's been really fun chatting with you today.
And you, Swee, and thank you.
Thank you.